that how have you studied your law in your last 3 or 5 years. If you think you are at least familiar with the subject, then you should think about it. And how you should think about it, go through the syllabus. If we just go on remembering all these maxims, it will not help. But if we understand the
and
context,
put it to the application.
Yes, if we understand the context and the concept, and then try to understand, okay, based on this understanding of negligence, this is something which we can add on, right? Topics like international terrorism.
Yes.
Like, so we have to gather enough material, enough content. But again, the idea is to ensure that we are able to write an answer.
How UPSC is it acclimatized with the BNS thing, or still new?
We will find out after this year's paper.
Achha.
We all, including me and the students, we all are waiting how the questions will be framed, because last year also this was the same conundrum. There was certain confusion, yes. But UPSC asked questions straight away from IPC provision.
Hello students, so welcome back to one more session of the optional, and let's churn law optional today, which is quite not very available everywhere. So we have Naveed sir today, and आज इनके साथ हम law optional पे वो सारी बातें करेंगे, those which are the questions of beginners sir, those who are willing to improve their ranks, and those who they are not from the law background, but still they are willing to take your law optional.
Yeah.
So how do you think sir, background की ही अगर बात करें तो how comfortable are the students who they are having 5-year का law, those who are doing LLB of 3 year, or those जिन्होंने कभी law background में देखा नहीं but still willing to, क्या ऐसे लोग हैं?
Yes, हैं, okay. Very few, but हैं. And there are a few examples also who have taken law not from a law background and cleared the exam.
Achha, that's really good.
Yes, so just one thing to start with. Law is just like any other optional which UPSC gives as an option. You can take it, right? Obviously, generally, since it's a professional and a technical subject, I would say, so law graduates definitely take. But even law graduates often call me and ask, sir, shall I take this subject because it's very lengthy, which is true. And sir, marks nahi aata hai. This is one of the general concern. I said, yes, both of your points are true, right? First point, regarding law, because most of them, like 99.9% of them are law graduate, I simply ask them 2 basic questions, that how have you studied your law in your last 3 or 5 years. If you think you are at least familiar with the subject, then you should think about it. And how you should think about it, go through the syllabus. When you go through the syllabus, try to understand that what sort of notes you have, which you have prepared during your college years, right? Because that will give them a true idea rather than me telling them. It's they themselves discovering whether how much they have prepared, not from an exam point of view, but at least the familiarity of the subject, obviously, which would be there. Then there are a type of students who are like very focused, who start their preparation, let's say from the 3rd or 4th year. They know what the syllabus is, and accordingly they have utilized their time for 4th and 5th year during the 4th and 5th year. I'm talking about the 5-year law students, right?
Yes,
even for 3-year law students, those who are undergoing 3 years degree course, I have met students who have taken admission or who want to start their preparation for law optional, even before joining their 3 years course, thinking that it will give them a slight edge even during their college preparation.
That is an angle.
Yes. So you see, there are different type of students thinking in a very different way, but all of them converge on this point that yes, they want to appear for the civil services examination, taking law as their optional subject.
Okay.
Another aspect
Talking of the lengthy subject, yes, or the lengthy syllabus of law. Sir, I believe whatever is lengthy has a vice versa effect on the general studies and the law area, right?
Again, regarding the length of the subject, yes, it's lengthy. Certain contemporary aspects are also added in the syllabus. So again, coming back to where I ended.
Yes,
so
sir.
Let's say a student has, suppose for example, 40 to 50%, they have a basic understanding. Now this basic understanding will also help them in the polity part, right? The very basic aspect, because that covers almost 60 to 65% of the GS2 syllabus.
Exactly.
Right? And when we when they study constitutional law, obviously they will study in a
The
slight
law of the
more,
land, definitely.
they
yes.
will study in a, not only that, they will study in a much more in-depth manner, like going through the cases, the majority judgment, the minority judgment, opinion of justices, what was the decisions on exact law points, for example, Sabrimala judgment.
Yes.
So their law students should know this, the various legal points which were decided by the Supreme Court along with the minority judgment, because currently that judgment is still under review. So they should also know that on what grounds the Supreme Court will further or may further give their judgment. This can be asked in the exam.
And I believe that the basic or the core concrete part of the law is actually something coming from the past. So the previous judgments, maxims are there. So the thing is, sir, talking of maxims only, that is a very different term actually, right? Certain we go through in political science as well, and whenever we are quoting the Western thinkers. But when it comes to law, there are n number of maxims to by heart, I must say. So what is your suggestion? How the student copes up with the same?
First of all, not only maxims, since you have mentioned about this, there are a lot of provisions, lot of sections, lot of articles.
Landmark judgments are there?
Landmark judgments. So let's start with the basic. Let's understand the context. So for example, negligence. How can we determine negligence?
Okay.
So res ipsa loquitur is a very famous, maxim of saying that thing speaks for itself. Means he was so negligent, and because of his acts, because of these things, what is negligence? Someone who has a duty of care did not take that care.
Okay.
And because of lack of care, certain activities happened, something happened which resulted in injury to the other party.
Okay. Yes.
So again, if we just go on remembering all these maxims, it will not help. Okay. But if we understand the
and
context,
put it to the application.
Yes. If we understand the context and the concept, and then try to understand, okay, based on this understanding of negligence, this is something which we can add on, right? Okay. So same goes with provisions.
Yes, sir.
For example, let's say, if I ask the students, tell me what provisions can be found in the Constitution which highlights a parliamentary form of government, because this is not directly written anywhere, right?
Exactly.
But so again, here the context becomes important. Article 74, Article 75,
yes.
All of this gives us an understanding and idea that we have a parliamentary form of government which is different from a presidential form of government.
Okay. And getting back to that statement, very important, marks nahi aata hai, right? Sir, one thing I believe, as I'm having this conversation, I can understand one thing or sum up one thing, that students, they have to go for not only paper 1 and 2 in law, but there are sub-subjects under law. There, every module or every topic itself a subject, right? So the thing is, there matters the study material, right? The compilation of a study material and the utilization of those particular compilations. So as a teacher, because law as a subject, sir, they are you cannot find a lot of study material, ready-made study material in the market, right? So the student, they have to go for numerous of books, okay? And the language itself is very different. You can have a difference of language in the book written D.D. Basu. I'm just comparing in Indian polity for all those UPSC aspirants. So what they study in Lakshmikant and what is written in D.D. Basu, they find it is very tough. Durga Das Basu has a different idea, right? And what is written in Lakshmikant is quite easy peasy, right?
It's in a simple language.
Yes, it's quite simple. So here, how would you suggest the student and how do you compile the study material so that they can take that to their examination or jahan marks zyada hai?
See, if you ask me how do I compile, I also refer to the basic standard books.
Yes, sir.
D.D. Basu, MP Jain, V.N. Shukla, so many, whatever are available. Even at times, I do refer to international authors to understand their constitutional viewpoints. Right?
Yes, sir.
But I do not recommend this to the students. What I recommend them is to understand the concept.
Yes.
Based on the notes which we provide.
Yes.
Based on the discussions which we do.
Yes.
And also the landmark judgments with respect to each topic. For example, parliamentary form of government. So we have a landmark judgment of Shamsher Singh.
Yes.
For example, basic structure doctrine. We have a landmark judgment of Keshav Nanda Bharti.
Yes.
For example, the harmonization between fundamental rights and directive principles. So we have a number of judgments Keshavananda Bharati, Minerva Mills, so many. So again, idea here with respect to UPSC preparation is not just collection of books or reading so many, because it's simply not possible.
Yes, indeed.
Right, because the syllabus itself, you're actually right, it's quite vast, and here we are only talking about just one subject so far. International law itself is so vast, right?
Yes.
So what I have done, I have personally took the pain of going through whatever is necessary from, let's say, an answer writing perspective.
Yes,
and
sir.
then accordingly incorporated the basics, the theories wherever it is necessary, and also certain current aspect. For example, a question was asked way back by UPSC under international law that why do you think India has not signed CTBT, Comprehensive Test Ban Treaty? Now,
Yes.
this is not something which will be there in a standard textbook. Maybe not, but definitely it forms part of.
They
in a
say
way,
there is no book for international relations as well.
Yes,
So no certain.
Exactly. So
You need to know the history and then you need to the present.
for example, topics like international terrorism.
Yes.
Like, so we have to gather enough material, enough content. But again, the idea is to ensure that we are able to write an answer.
Yes, very
And
much.
the guide is whatever has been asked by UPSC, and if there are any current developments along with certain basic aspects of international terrorism or similar subjects like WTO or TRIPS or international environment law. So again, we have to understand the requirement of UPSC, obviously based on the syllabus, and then map that syllabus along with the previous year's questions, because that gives us a absolute clarity. Else, there's no end of studying.
Exactly.
There are so many
Indeed,
materials.
there is
right?
no. Okay, sir. There is this new introduction of BNS
Yes,
and
of course.
IPC and Penal Code. So, what I am thinking, how acquainted, like it's the last year's paper which you can get an idea from. Okay, is UPSC like normal courtroom is now getting acquainted with the BNS, or the regular people are getting acquainted with the BNS and the difference of IPC and BNS? How UPSC is it acclimatized with the BNS thing, or it's still new?
We will find out after this year's paper.
Acha.
We all, including me and the students, we all are waiting
Okay.
how the questions will be framed, because last year also this was the same conundrums. There was certain confusion,
Yes.
but UPSC asked questions straight away from IPC provision.
Okay,
right?
okay.
Simply asking.
Okay.
Like death caused by negligence and
Yes.
simple other
Culpable homicide and
yes,
all, yeah.
exactly. So let's see what happens this year. But the thing is, when we talk about BNS, Bharatiya Nyaya Sanhita,
So I will just request you to add the simple idea of, let's say you are saying BNS and comparing BNS and IPC. Please do tell me the idea of incorporating solution for this.
I'll tell.
Yes.
I was coming to that. So first of all, let's wait for this year's exam.
Okay,
I think we'll
one.
have a clarity one.
Yes.
Second, coming to BNS or IPC, whatever crimes or whatever cases are still going on for those offences which happened prior to July 2023, I guess.
Yes.
For that, IPC provisions are still there, going on in the code for CRPC, and whatever offence have taken place post July when this new law was notified, for them BNS would the charges under BNS would be there.
Yes.
Now coming back to the answers, the solution. So the solution is very simple. First of all, when the government came up with the Bharatiya Nyaya Sanhita, obviously there would be certain changes.
Yes.
First, what are those changes? How is it any different? And what, obviously something new would have been added. So what new things have been added, right? For example, community punishment has been added as a form of punishment, which was not there under the Indian Penal Code.
Yes.
For example, the word sedition is not there under the Bharatiya Nyaya Sanhita, which was there under
IPC, yes.
But apart from few changes, the basic concepts remain the same.
So the students should have a comparative analysis, or the teacher should also be ready with the comparative analysis of both.
Students will get that comparative analysis.
Okay, so you are working on that.
No, it's already prepared. So students will get that comparative analysis. But again, I'll just explain this through an example. If I'll ask students, or let's say if a question is asked to differentiate between culpable homicide amounting to murder and not amounting to murder, the concept still remains the same.
Okay.
Yes, the
Indeed.
provisions will change.
Yes, provisions are
299 will become 100 or 101. But the concept remains the same. Let's say the same applies to the difference between kidnapping and abduction.
Yes.
Right? Or any other like theft, extortion, robbery, dacoity. The concept remains more or less the same.
Yes.
What has changed is the provision, like this section. So students should focus more on understanding the concept, because UPSC, if we look at the nature of questions asked, then the concepts is something which we need to highlight. And let's say if someone is right, even someone, because this year students have prepared a comparative note, and I've told students that if you don't remember, just don't write the provision, right?
That can, we can refrain that.
Just write IPC.
Okay.
As long as UPSC says कि IPC नहीं लिखना है.
हाँ जी.
Right. As long as that happens. I don't think that has happened.
Yes.
So I don't think there is any problem so far with respect to IPC or business, but I'm sure this year we'll have that clarity also.
Okay. So if I sum up this session, or the bottom line for this session is to write more, to read. It is very important to read more, right? This is a bulky syllabus, but it should not be seen as a bulky syllabus. Rather, we can differentiate and we can add new things to it. We need to be current updated, okay? And there should not be fear for BNS and IPC changes.
I just want to
We should be ready.
Yes, I just want to add just one thing, as you rightly pointed out, that students should prepare it section-wise, like paper 1, section A and section B.
Okay.
So paper 1, section A is constitutional law and administrative law.
Yes, sir.
Right. Paper 1, section B is international law. This has to be thoroughly prepared, because there is only 3 papers here in paper 1. Now coming to paper 2. Now paper 2 becomes slightly tricky because there are a lot of subjects. The point which you were earlier highlighting. So in paper 2, section A, one should focus on the criminal law and the law of torts.
Okay.
And in paper 2, section B, one should focus on mercantile law, and then on certain aspects of current developments, that is legal contemporary developments, along with elements of contemporary law like Negotiable Instruments Act or other aspects of international environment law, etc. RTI, Prevention of Corruption Act,
Yes.
all of that. So that's how students should focus their preparation.
So I believe you suggest those students who have the law optional to be ready with their pen to pen down. There are numerous of changes going on, right? Any landmark judgment can play a vital role. So it means there is no end to the current affair into this, is it?
As long as that landmark judgment corresponds to the part of the syllabus,
Okay.
then definitely that must be studied, because anyways that would be required even under GS papers.
Exactly.
For example, let's say any changes in environment law comes, then that is also a part of the GS3 studies under environment aspect.
Definitely
So under law, obviously, let's say a landmark judgment comes with respect to any aspect of the Constitution of India, and that has to be understood. Suppose ICJ comes up, International Court of Justice comes up with certain decision which impact some parts of the syllabus, then that needs to be understood.
That's very important that way. So finally, sir, I would like to ask one last thing to you. Please motivate certain words to motivate your student to do good with this idea of law optional, and to actually dismantle this idea of marks कम आता है. I think आप जितना आपने कम एक्सप्लोर किया है, शायद इसलिए मार्क्स कम आ रहा है. चीज़ें मटेरियल थोड़ी और डेप्थ में कर सकते, थोड़ी और मेहनत कर सकते हैं, थोड़े और आंसर्स लिख सकते हैं.
As far as marks is concerned, see, you have to write what is being asked, not what you have remembered or what
This is
you have
more like
studied.
science.
This is it's simple demand and supply.
Exactly.
What is being asked, you're not supplying that, then obviously marks nahi aayega.
Charts and tables are
now
a part
comes
of it.
the second part, ki whatever you are supplying, as in the whatever answers you're writing, how in depth those answers are, whether those contains case laws, whether those contains, if at all relevant aspects are being asked, are you highlighting those aspects, or whatever the key aspects is being asked, are you highlighting those key aspects? For example, I'll just give you an example, ma'am, that for example, if a question is asked that how do you see reservation under the Constitution of India?
Okay.
Is it an exception to equality or is it a part of equality? Now this is a tricky question.
Is it?
But-
Indeed.
But to answer this, you need to know those case laws where things changed in terms of understanding. Now, why we study landmark judgments? Because in those landmark judgments, the point of law changed.
Yeah.
Right.
As well as case studies.
Yes. For example, case of Nanda Bharti, the law of point changed that power of Parliament to amend the Constitution is not unlimited.
Yes.
It is
the
limited-
basic structure.
It is limited by those basic structures.
Yes.
Similarly, with respect to reservation, in the case of N.M. Thomas, it was highlighted, the Supreme Court said, that reservation should not be seen as an exception to equality,
Exactly.
but rather as a facet of equality. Now, this further elaborated the concept of equality to substantive equality.
Exactly.
And so many aspects. So, again, it's not about marks. It's about whether you understand what is being asked and whether you're actually writing,
in a right manner or not.
And then, of course, the structure, the case laws are important. Like, students, I must tell you, for law optional, case laws are important.
Okay.
And without case laws, if you're not writing case laws, and especially if the question is based on that case law, then that case law has to be mentioned. So this is one point student must understand, and this applies across all the subjects: constitutional law, law of torts, mercantile law, criminal law, or even international law. Case laws are important. For example, if we talk about customary international law, then you have to mention about certain cases which establishes that yes, customary international law comprises of actual state practice and opinio juris. So again, we need to understand what is being asked and exactly write the our answers based on the relevant question.
That's really a great session to have here, and I would suggest all the students, those and especially those who they are not from the law background and still taking the law, I think they are the most wonderful people here. So I would just suggest work hard, write numerous of questions, and stay tuned. Signing off. Thank you so much. Thank you.
Thank you, ma'am.